Hello, everyone, and welcome to this module. This module, we're going to talk about civil rights and the people of the United States. All right, our civil rights as citizens of the United States of America. And when we say civil rights, what we're talking about is when cases discuss a group typically defined along ethnical or racial lines, when they are denied access to certain places, facilities, opportunities, even or services that are readily available to other groups. All right, so when we talk about civil rights cases, what we're talking about is when some group is denied access to facilities, opportunities, or services that other groups may have the privilege of using. All right, so in civil rights, the question isn't whether the government has the authority to treat people differently, it's whether such differences in treatment is reasonable. All right, because sometimes it may be reasonable. All right, the government carte blanche can't do it, but we have to discuss and decipher and think about, analyze whether such differences in treatment are reasonable, and then we can go from there. All right. An example of reasonable versus unreasonable: treating people differently because of income, taxing them differently, is reasonable. Okay, that may be reasonable. All right, you're distinguishing one group of people from another based on their income, while taxing them differently. That may be a reasonable thing to do. Treating people differently because of their race, ethnicity, gender, or sexual orientation is not reasonable. No. All right, that's not reasonable. Income, yes. Race, ethnicity, gender, and sexual orientation, no. All right, so the key to civil rights cases is the 14th Amendment. All right, the 14th Amendment of the Constitution. It was passed in 1868, post-Civil War. And what the 14th Amendment states is that no state shall deprive any person of life, liberty, or property without the due process of law. This is the due process clause, part of the 14th Amendment. The second part is no state shall deny any person within its jurisdiction the equal protections of the law. This is the equal protections clause. All right, so the 14th Amendment is made up of two parts: the due process clause and the equal protections clause. All right. The due process clause means you have the due process of law. You cannot be denied anything, life, liberty, or property without going through a process of law. The equal protections clause says you cannot deny any person within the jurisdiction the equal protections that the laws are afford them. Okay, so equal protection under the law, if read broadly, means no person, no matter what background, should be treated differently from any other person with a different background. That's reading it broadly. Reading it narrowly is a little different. Okay, reading it narrowly is a little different. Equal protection means only certain fundamental rights are protected. All right, other than those, people from different backgrounds can be treated unequally. All right, so if you read it narrowly, reading the Equal Protections Clause narrowly, well, they only apply to your fundamental rights. And that's what narrow interpretation of the Equal Protection Clause means. Right, only certain fundamental rights. Other than that, you could treat people unfairly, unequally, doesn't matter. All right, so what are some fundamental rights? The right to sign a contract, to serve on juries, and to buy and sell property. All right, so if you read it narrowly, that's what you're kind of talking about. All right, so the equal protection under the law. Courts have interpreted that the Equal Protection Clause should be read narrowly. This is the interesting thing, right, for us political science people and lawyers to be. What has happened over the years since 1868, this Supreme Court specifically, interpreted that the Equal Protection Clause should be read narrowly, not broadly. And as a result, it held for the most part that the 14th Amendment, again, for the most part, only applies to the federal government and not to the states. All right, not to the states. Even though it kind of says states in it. So does it make sense? I don't believe so, but it is what it is, right? This is the way the court has interpreted it. All right, so therefore, in the court's interpretation, the Equal Protection Clause needs to be read narrowly. All right, so All right, so the major cases that determine that legal status of equal protection clause of the 14th Amendment is Plessy versus Ferguson, right? This is one of the major cases. Plessy versus Ferguson, decided in 1896, some 30 years post the passing of the 14th Amendment. Plessy versus Ferguson, basically, it was Louisiana law that required black and white people to occupy separate cars on a railroad line operating in that state. All right, so there was a law in the books in the state of Louisiana that said black people, white people have to ride in separate cars. As long as that railroad car was operating in the state. If we're not a state, then that's a different story. But if it's operating within the state, intrastate, then they have to ride in separate cars. Now, it just seems like it's a violation of the Equal Protection Clause, right? You're treating people differently, not providing them the equal protections under the law. But the interesting thing, and it still blows my mind, is the U.S. Supreme Court held that the law treated both races equally, right? Well, you both get to ride in the train, even though they require them to be separate. And this is where the separate but equal doctrine came into play. Okay, so Plessy versus Ferguson is known as the case that set up the separate but equal doctrine. The U.S. Supreme Court said it was legal to separate as long as people were treating equally. And in this case, well, everybody got to ride, both black and white people got to ride on the train, even though they were separated. It was equal that they got to ride. Even though they were separated, it's not a big deal. All right, so Plessy versus Ferguson held that separate but equal doctrine is applicable. And that should be the law of the land, right? Because it's the U.S. Supreme Court that's doing this. Wow, right? Take that one step further. In Cummings versus Richard County Board of Ed, the court held that a community in Georgia closing their high school to black students while keeping one open for white students was not a violation of the 14th Amendment. What are you talking about? This doesn't make any sense. The reason it says black students can always go to private schools. The reason behind this, all right? So a whole town, a whole community closed their high school to black students while keeping one open just for the white students. And the court said this is not a violation of the 14th Amendment. Why? Because black students could always go to private schools. Holding that not only could schools be separate, they can't even be unequal. All right, so this took Plessy versus Ferguson and pushed it a little bit further. This case held that separate. Yep, because it's separate. Black, white schools are separate, but they can even be unequal. All right, so this is where the rabbit hole that we're going down. So the question you have to ask yourself as a student is, can separate ever be equal? Right? So think about that, right? Can separate ever be equal? I don't know. All right, so this was a law of the land, Plessy versus Ferguson, in the Georgia case, or the law of the land, up until 1954. Another 50, 60 years had to pass until the case of Brown versus Board of Education. Right? And this was totally different. In a unanimous U.S. Supreme Court decision, the court held in the field of public education, right? So when we're talking about kids getting educated, the doctrine of separate but equal has absolutely no place. All right. Separate educational facilities are inherently unequal. They're inherently unequal. You may say they're equal. They may provide the same things. Nope. They're inherently unequal in the court's view. And therefore, Plessy versus Ferguson was kicked out. It was overruled. The U.S. Supreme Court has overruled itself. All right. Kicked out separate but equal doctrine, saying that separate education facilities are inherently unequal. Just on their face, unequal. All right. So because of this, the separate but equal doctrine, dead in the water. We have a new law as of 1954. It's Brown versus Board of Education. All right. In that case, the court also determined that federal district courts would oversee the end of segregation in the schools and gave them the power to approve or disapprove local desegregation plans. All right. So that's kind of interesting. So the court stayed involved in this process until desegregation happened. All right. And the court even said to do this with all deliberate speed. We need to do this now. We are so far behind on this issue. We need to use all deliberate speed to desegregate the schools, integrate the schools, and gave the federal courts the power to make sure that it does happen. All right. And did it happen? Well, 6 years later, a 6-year-old girl named Marie Bridges became the first black child to desegregate the all-white William Fitz Elementary School in New Orleans. There she is. All right, there's a young woman walking down those steps. So that even took 6 years, right, to desegregate. So I don't know if that's with all deliberate speed, 6 years. But as you can see, took in New Orleans, it took them 6 years as Ruby Bridges walked down those steps. Now, this is, to me, is just a photo of bravery, in my opinion. So that's what Brown versus Board of Education did. It took, ruled in 1954, but it still took the city of New Orleans 6 years with all deliberate speed to desegregate their schools. Alabama, not much better. 1963, there's the governor of Alabama at the time, Governor Wallace, stood in the doorway of the University of Alabama to block entry of black students. So there he is, standing there. All right, nope, you can't come in. This is almost a decade after Brown versus Board of Education, still fighting to say, no, we're not going to do this, we're not going to do this, we're not going to desegregate, we're not going to integrate. And it's the governor of the state at the time. So we think about desegregation, integration. We got to think about it in two different ways. There's de jure segregation, where the racial segregation is blatant. The law says, like the train case in New Orleans, that's racial segregation, blatant racial segregation, right? That's the law. And then there's de facto segregation. And what this means is racial segregation that occurs not as a result of law, but as a result of patterns or of residential settlements, right? So it happens because the way people live, right? Where they live. And this, then we need to think about this when we're thinking about law and how to implement laws and how laws should be applied and that kind of thing. All right. So finally, 10 years after Brown versus Board of Education, the Civil Rights Act was passed in 1964. And the Civil Rights Act prohibits discrimination on the basis of race, color, religion, sex, and national origin. And it also prohibits the unequal application of voter registration requirements, racial segregation in public schools and public accommodations, and also in employment discrimination. So even 10 years later, even though the Brown versus Board of Education kicked out Plessy versus Ferguson, 10 years after, we still had to implement the law. And what are we? 50, 60 years plus from that, we have to ask ourselves our questions. Is there still discrimination? Is there, does it still happen? Do we see it? And what can we, as young political scientists, lawyers to be, do about it? All right. That's the questions for tonight. Thank you very much for your time. I'll see you next time.